First of all, I must apologize for the last week's just a shortened session. But since then, during the week, I got several requests to repeat the discussion that we had last week. So I thought I'll do a brief walkthrough of that presentation, because designing and implementing a compliance plan and compliance policy in an organization is very vital. So I'll go through that again. And then arising out of that, I have chosen two specific areas which are very important in our financial services organization, like treasury operations and then international trade operations, how the compliance could add value to such functions in your organizations. So in all, I will have about 3 presentations to cover today. And ironically, now the allocated 20 hours have been covered by me, by us. So we'll try to finish all 3 PowerPoint presentation during the course of these 4 hours today. And but that doesn't limit any of your comments or questions that are coming up. So please ask questions if you don't understand. I would rather receive your comments and then seek permission from IBSL to carry on the session for next day as well, if necessary. So otherwise, now there are about 23 participants logged in now. Let the others join in on the course of our presentation. So meanwhile, I want to ask you all are vaccinated, right? That's very important, because the way that the virus is spreading. Can you see the screen?
Yes, sir.
Very good, very good. Thank you. So this this is about developing a compliance plan in your organization. Basically focusing on compliance on consumer protection, KYC, anti-money laundering, and combating of financial terrorism requirements, and outsourcing of business operations. So around all these areas, covering basically there is no function of a financial organization that doesn't come under the purview of compliance. And if I may summarily present it, compliance is the function that will supervise and oversee each and every operation, each and every function, each and every product of your financial organization. So let's walk through. As we discussed, in our financial services industry, there are 3 regulators responsible for the central bank being responsible for the depositors' protection, rights and claims, and SEC, Securities Exchange Commission, responsible for investors' rights and claims and protections, and Insurance Board of Sri Lanka being responsible for the rights and claims of insured or the insurance policy holders. So that we discussed last week, little in depth, but in summary form, there are 3 regulators. There are 3 regulators in our financial service industry in Sri Lanka. Basically, their role is to protect these guys, depositors, investors, and insurance policy holders. So in terms of numbers, as you all know, the Central Bank of Sri Lanka and the SEC and Insurance Board have been incorporated by Act of Parliament, and they have been vested with such responsibilities because they themselves do not interact with the end users, but there are intermediaries. Now, in the case of Central Bank Sri Lanka, there are about 24 licensed commercial banks, about 11 licensed specialized banks, and about 39 or 40 registered finance companies. And then also there are primary dealers, various funds that are being created, and money brokers, and so on, other ancillary institutions as well. Then when it comes to SEC, basically the stockbrokers, stock exchange and stockbrokers, and then a few unit trusts and some other funds who would engage in the services to the investors who expect the profit, gain or loss, other than the legitimate interest claims or dividend claims. Because there are the difference between the depositors and investors seem to be the depositors are, their capital is 100% insured by the Central Bank of Sri Lanka, whereas in the part of investors, the insuring of capital element is subject to the capital gains and losses. So, and then the insurance policy holders are protected by the Insurance Board of Sri Lanka. There are about 22 insurance companies operating in Sri Lanka, serving the needs of insurance of the general public. Right. So that's a summary of the broad picture. So when we speak of all those financial intermediaries, they have a bounden duty to comply with the Parliament Acts and sovereign directions and the rules and regulations and directions by the regulators with the aim of protecting the end user. So a business without compliance to those regulations and rules could be dangerous to all stakeholders, including the entire economy. But a business with compliance regime or compliance plan will benefit all stakeholders because they are designed to ensure the protection of the end user, which is the common society. So, and the specific economic goals in each sector, and these sectors are divided as their functionalities differ, and then shared between the three financial regulators in our country. So therefore, an entity with the compliance rules and regulations are very much valued, and then anybody trying to step out of the compliance rules and regulations can be pointed out by the end users in the first place. Secondly, the regulators can find them out, isolate them, punish them, or try to realign them to the compliance regime. So that's the basic macro picture. Then we discuss how a professional in an intermediary like a bank or a finance company or a primary dealer or a stockbroker or insurance company could execute their duties, fulfill their duties in a summary form, how they could execute their duties professionally in compliance with the rules and regulations. First of all, I have listed down 5 rules, 5 golden rules. Each and every professional and each and every organization.
Excuse me, sir.
Sorry?
Excuse me.
Yes.
Absolutely sorry for disturbing.
No, you are most welcome. Please come forward.
Sir, kindly tell us when is this PowerPoint was shared with us, sir?
Last afternoon, it was shared on the Google Class.
Is it
No,
possible?
sir, it was shared today morning.
Sorry?
It was shared today morning.
No. I think Mr. Menaka, Assistant Director, Institute of Bankers, because few of your participants requested me over the phone and by email and by WhatsApp message to upload the presentations at least yesterday so that they can download and then read and come. So
Yeah, sir, but we didn't receive those. So just now only we are seeing this, I think. Isn't that so?
That I don't. That's correct. I got confirmation from Mr. Menaka last evening as well. They had uploaded it. And mind you, this particular presentation we discussed last Sunday as well. And then last Sunday also. Sorry?
It was there, sir. Last evening it was there.
Kavi, yes.
It was there.
Yes. But of course, between last Sunday and today, I have updated a little bit. One or two slides I updated. But yesterday, Kavi, ईएम में अपलोड करा नहीं है मैं क्या कविंद्र anyway but you can read now if you have not seen yesterday, but I welcome any question, any comment during the course of discussion. And then even after today's discussion, if you need any support, any clarification, you know my phone number and my email address. So I am open to any sort of questions, queries, and comments. We can discuss on a positive note. There's no issue. All right. Okay, let's get back to the presentation because of the time constraint. So any professional in an intermediary or financial services organization, if they follow these five golden rules or 5 precepts, if I may call it, namely, firstly, identification. Identification, how do we identify? Through know your customer, through customer due diligence, and through enhanced due diligence criteria that have been established. Right? There's no question about it, right? So identifying your end user and the customer that to whom you are going to provide your services or products, there should be a proper identification. Because as you all may have learned before, because it's a basic concept, anybody in the society trying to resort to socially unfriendly or activity or illegal activity has to be identified by these professionals in the financial service industry, in banks and in finance companies and any other insurance company or any other intermediary organization. So they need to be possessing at least average intelligence, and then looking at these business operations or business activities or economic activities of these end users who who approach the financial intermediaries about their details, know your customer details. Those details does not limit to their contact number, postal address, NIC number, and place of employment, and then all that. We will discuss in the next few slides. The finding out of details of end user is the total responsibility of the intermediaries and the professionals who are being employed by these financial organizations. It is their prime duty, as evidenced by the recent amount of penalties levied by the FIU in Sri Lanka and elsewhere in the world, mostly the financial penalties have been levied on the inadequacy of KYC, CDD, EDD capabilities of the financial service industry or intermediaries. So that is very evident, and that is expected at the most opportune, most optimum level. So the practicing of obtaining the details of the end user cannot be compromised, because the regulators per se, as we indicated just a while ago, they don't interact with the end users, the general public, but only the intermediaries and the professionals employed by them only interact with the end users or general public. So that's very important. That's the concept practiced. And then the capabilities of know your customer data obtaining, and then CDD and EDD is paramount important. Let me repeat that again. So, and quite positively, current modern day technology, especially the core banking systems that are designed, any other computer systems are used by these intermediaries, facilitate obtaining and recording of such KYC and CDD, EDD data of each customer at a comprehensive level. If I may recall my experiences, I think about 30 to 40 pieces of information of each client can be obtained and recorded in the core systems. And the usefulness is that when you record those key KYC or CDD, EDD data of each customer, when anybody employee of the same institution retrieves or want to identify this particular customer or want to do the next transaction with the customer, online the core system will prompt, or the user of the computer system can retrieve the customer information online wherever the branch is, because of anywhere banking facility. So therefore, that's a very positive, and then very thanks to the modern day technology, unlike those days where the people had to refer to paper files in locating the customer data. But my word of caution is that if in your organization that you are working for, if this KYC or CDD, EDD data is not housed or saved in your core systems, please arrange as quickly as possible to save them and to be able to be looked at by anybody who's focusing on that particular customer, individual customers, maybe at varied levels, individual and corporates and anybody. When it comes to corporate customers, there are much more KYC information than an individual customer about the people who drive the business of corporate entities, the directors, major shareholders, and then company secretaries, and then auditors, and various and key fund managers of treasury managers of each corporate customer. Those data can be saved in your core systems to be able to identify what they do, what they are, and what their intentions are, what their risk appetite is, and so on and so forth. So next, review or monitor. With the regular interactions of this particular customer after onboarding, with the regular interactions of these customers accounts, the facts obtained initially, KYC, CDD, facts obtained initially may change, will definitely change. Day by day, week by week, month by month, they tend to change. At least the business organization will positively grow with economic increased economic activities, increased demand, and various other finances, and then support by the financial services organizations, they can grow faster, and they can number of outlets, number of employees can increase. So such review and monitoring and then updating of KYC CDD EDD data is very important, so that it is the data can be used by any employee of your organization to identify those activities and the intentions and the needs of such customer, because that helps to cater to improve your relationship with the customer as well, very positively, if they are very legally operating customers, and they will want definitely more financial transactions, more support from the financial organizations, intermediaries, and when they grow with their needs growing faster, so their facts and figures, KYC, CDD, EDD data has to be captured, so that your organization as a financial service provider also can grow with the growing relationship with your customers very positively. But on the run, if anybody is not behaving or not conducting their business operation in as expected as the regulators or as the rule of law, they can be reported. Next item, reporting of suspicions. Because as bankers and finance company employees and then intermediary financial services organization professionals, we are not expected to behave as detectives, but we are expected to use our common intelligence, common sense, because those employees, those people who enter the services of financial industry are expected to be at least qualified to that position, and then possessing at least average intelligence. So when you identify suspicion of illegal activity, if the gravity of that activity is not so grave, you can have a discussion with those parties and then try to correct them. Because most of the illegal activities start with a small action, illegal action. Then when they feel the taste of it, and then the free money or free easy money that is coming through, they might start on a bigger scale, at which time the law enforcement authorities will have to come in to combat such illegal activity. So initially, but however, if the suspected illegal activity is on a large scale bribe taking or human trafficking or misuse of funds, or you know what the illegal activities are, extortion and so on, then you are expected to obtain more information of such activity through confidential mechanisms created by you all within your organization, and the compliance officer or compliance department have the access to the FIU's portals, Lankafin and then GoML, such portals, online portals, just to fill in a few lines, especially the reason for suspicion and the customer account number and details and address. Sorry. And then submit such STRs, so suspicion transfer reports, very quickly to the FIU. So that that will prevent, and all this process has to be very, very confidential and should not go out of hands. So for that reason, many organizations, they keep these such reportings to the knowledge of the compliance officer who submitted the report, and the persons who, one or two persons who identify the suspicion at the branch level or any business unit level. So that the information of reporting such activity to the regulator does not go to the suspected customer or any others in the society. Sorry. So that helps to keep the confidentiality, and at the regulator, FIU, or subsequently who will be assigned to investigate such activity, like bribery commission, excise department, or any other, or CID, or any other law enforcement agency, they will never divulge the fact that these suspicions have been reported by such an organization, such an individual. They will never divulge. So, so you can take comfort of that. So we discussed 3 golden points: identify, review, monitor, and then report. So the reporting STR, the main aim is to keep the confidentiality and then try and take all measures possible to correct such individuals who resort to illegal activities in the society. And the 4th one, record. Keep the records of KYC data, CDD data, EDD data, plus any investigations and reporting of STRs for 6 years. The FTRA requires keep a record for 6 years. So, 6 years, and if there is any query or investigation on, until the investigation or query is over. And this record keeping helps the professionals in the financial services organizations to prove such belief by the financial services organization or the professionals involved, documentary evidence, and then computer saved data. At a later date, if your understanding about the customer is wrong or different, because we are all human beings, we can make mistakes, you can always present yourself as the organization or as individually in a court of law or in a law enforcement agency or to the regulator, that depending on the evidence that we have been supplied with by the client and was available in the public domain, we believe this person, this activity, these transactions were this sort. So therefore, we are quite innocent because we are not detectives. So the record keeping helps out of danger in a difficult situation for your organization and for yourself. So that's the 4th one. The 5th one, I have put in a different color because that is the facilitate risk optimization by business managers or risk-based approach evaluations. This is very important. Not many textbooks and syllabuses discuss this factor, but the importance of compliance in driving the business organization activities, if they don't focus on this risk optimization matter, then there is possibility, there is potential that the compliance guys, compliance community will clash with the business lead, the business heads of businesses or employees of business units all the time. Because compliance officers and compliance employees, compliance department employees are also paid by the same organization, and they are colleagues at the business units and the heads of business need assistance by the compliance officer and the compliance department to conduct their business, to interpret the new regulations, to how to apply business activity and how to conduct the business activity without contravening the regulations, rules, and sort of things. The compliance guys must be holding the hands of the business guys and driving the business of the organization together. So the meaning of risk optimization is that if there are any rough ends which conflict with the rules and regulations by the regulator or by the directors or the shareholders, compliance should impose circumvented or slightly dented mechanisms to overcome the confrontation with the law or the requirement by the internal authorities. So thereby, if you really mean or demonstrate that you are there to support the business leaders of your organization, you will become friends. And there the conflict or the frictions between the business leaders and the compliance leaders of your organization will not be there anymore. So your practicing or teamwork will be encouraged, so that compliance community will be well received by the business leaders, and they will look up for advice. They will look up for advice each time then there's a difficulty. So that is the environment that the compliance officer and the compliance department should create within your organizations. So these 5 golden points are very important to professional business of compliance. So the creating of such environment again comes back to the compliance head and the compliance department to identify KYC, EDD, CDD data, to facilitate review and monitoring of regular interactions with the customers, and updating the core systems, computer systems, and then to facilitate reporting, confidential reporting, to facilitate comprehensive confidential and then comprehensive reporting and analysis, and also to facilitate record keeping. So this type of activity, the infrastructure creation should be led by, or at least supervised by, the compliance. That means they have to have a hand in the IT department or computer divisions, and as well as the HR divisions. We are selecting the appropriate people, employees to the appropriate business line, and the operations department in creating the facilities of reporting requirements, and then other infrastructure, and facilitating risk optimization, as we discussed a while ago. So these aspects has to be really focused, and therefore I need not tell you right now that compliance employees has to be knowledgeable in all aspects of the organization, all aspects of organizations. Maybe treasury, maybe trade finance, maybe credit administration, maybe credit approval, maybe leasing, maybe credit card centers, debit credit cards, and any activity of your organization has to be a deposit taking, any activity, they have to have a thorough knowledge. For that reason, the compliance department number of employees also at least minimum there should be a 3% of the total staff cadre should be in the compliance. 3% as a norm. But I know many large organizations there's much more. But at least 3%, those small organizations sometimes might pursue a cost-effective parameters. However, the importance of compliance is cannot be underestimated, because compliance will understand the rules and regulations imposed by internal shareholders and board directors and the senior management on a major scale, because your driving of business happens with their directions, with their rules, regulations, and the requirements. They have to be fulfilled in the first place. Then secondarily, the external organization like the regulator, the parliament, or the sovereign authority, and the various other stakeholders will have, outside stakeholders will have requirements like accounting standards, and then SLFRS 9, LKS 39, and so on and so forth. There are standards to be maintained on financial reporting. The compliance guys will have to have overall knowledge of all that, and then help finance guys, operations guys, computer guys, and then treasury guys, trade finance guys, credit department guys, deposit taking institution, liability management guys, all have to be supported by the compliance unit. Any question up to now?
So, is that 3% is from the total employee card of the organization, or?
Yes, as a norm, as an international, what I read this in some publications and compliance journals in the world. 3% of the total staff cadre should be in compliance. That is an average, depending on the rules and regulations, the complexity of rules and regulation of each country, each regime. It's an average. Yes.
Okay, thank you, sir.
Yes. Any other comments, questions? No? So I take it that you all have understood so far up to now this point. So let's move forward. So know your customer starts fundamentally. Now, when I say starts, now from decades and centuries ago, when the financial services industry started, identifying the customer has been the norm of the industry, the basic principle of basic practice. But as a recorded and as a legally enabled phenomena, we take Financial Transactions Reporting Act number 6 of 2006 and section 2.1 as the documented, legally enabled know your customer requirement. Why is this? To enable compliance, to identify customer needs, to identify investment objectives of our customers, to identify the strategy of the customer and his operations. Know your customer broadly, you know. Then understanding the financial objectives of the customer. Understand the risk tolerance or risk appetite of the customer. Understanding liquidity requirements of the customer. Understanding the investment objectives of the customer. Understanding investment preferences of the customer. And understanding the tax position of the customer. All that, you know, as evidenced by the authorities, tax evasion is an offense although in Sri Lanka is not under any predicate offence there so far, but elsewhere in the world, tax evasion is taken as a predicate offence for money laundering as well, because anybody earning, doing a business activity, doing transaction, and then having an income through the use of the infrastructure created by maybe the road network, maybe the telecom network, maybe the electricity supply, maybe the health services, hospital network, maybe the primary education, primary, secondary, tertiary education systems. They are created by the authority or the sovereign authority of the government at a cost. So they need to be maintained, and primarily the maintenance of peace. Remember those days when the civil war was in every countryside, every junction, there were bombs going off on the trains, on the buses, and then there was no peace on the country. So then to maintain the peace in the country, government has maintained the police and the security forces. So each and every person who's having an income, he has to pay a portion to maintain, his or her portion to maintain such services as tax. So as individual items, obtaining copies of identification documents, NIC, passport, driving license, and so on and so forth, and permanent residential business addresses, contact numbers and email addresses, and occupation and employer name and nature of business and expected income, and then reasons for opening the account and other transaction. Such are minute and then detailed KYC, CDD, EDD transactions. I think since you did the assignment also on the KYC, I need not explain much more depth there, but you all have done a satisfactory assignment, and then you'll have got all have got satisfactory marks on that. So I take for granted that everybody understand what is the requirement of KYC, CDD, and EDD. Then comes to in our compliance, designing of compliance plan. So up to now, I explained the fundamental and core requirement of KYC, CDD, EDD in your compliance plan, compliance policy in your organization. So from now on, we go on to ancillary other requirements to be embedded in the compliance plan in your organization. I understand you all did a assignment to Mr. Rupa Singh as well on similar lines on compliance policy, and then so you will have had a better understanding of that by now. But let's discuss customer charter direction by the regulator. Customer charter direction. This is to basically demonstrate that when you start a business, when you do your personal business or individual business or a corporate business, how you are going to provide your services or products to the customer, and what are the benefits that the customer is going to enjoy out of your services or products, and how best you are going to manage or administer these services or products to the customers. And this is a direction aimed at publicizing your intentions and then how you should be conducting your business activity. And this business customer charter provisions must be made public. Most of the financial organizations has done customer charter policies for your organization and then displayed in your websites and displayed in your lobby, customer area lobbies for customers to look at and understand how best that they could make use of your services, your products to enhance their livelihood. So this is a direction by the Bank Supervision Department of the Central Bank of Sri Lanka and sets the standards of fair banking practices envisaged by the customers. Information of understanding the banking products and services. Information of understanding of the banking products and services or financial services products and services. And key facts document for each product. What is key fact document? For each product that you or each service that you offer to a customer, the features, key features must be listed in a brochure or in a website, and then for the customer, for them to read and understand the benefits that they are going to derive when they use your product, when they use your service. Key fact document, the key features. Say, for example, in a savings account that you will pay average savings rate or any benchmark that you are going to base on, and how the interest is paid every day, or every week, or every month, or every quarter, or every 1 year, and how the interest is computed, and so on and so forth. The absolute interest rate can be a varying factor, need not come into the key fact document, but the methodology of computation of the interest rate and the interest calculation must be explained in the key fact document for the savings account, and how the balances can be weaved and then obtained through the savings passbook or e-savings statement, or whether you are going to provide access to web access to the computer of your organization for each customer to weave their balances and then transact through the e-connection, web connection, and all those key fact documents must be really explanatory to the services that you are going to provide. Then awareness and understanding of the terms and conditions of the products and services. Periodic statements to customers printed or electronic forms. Now, periodic statements, printing passbooks and then statements for current accounts may be costly postage involved. For that, now the financial intermediaries like banks particularly try to provide the e-statement increasingly, so that it's a matter of email or password protected email or something which is absolutely very low cost compared to the printing and then postage involved. Then financial literacy programs enhancing the knowledge of the customer to select the best product, best service that they need to obtain from your organization. For the benefit of the public and our customers, you can make it a marketing event to explain the financial products and services that you provide. For the benefit of our staff, for the staff, again, it is going to be knowledge enhancing and then the guidance for the staff as well in promoting and then acquiring more business from your customers. Another part of the customer charter is that the code of conduct for employees aimed at customer protection. your employees number who are the business frontline, front office staff who interact with the customers regularly, and also back office staff whose customer transactions or processing the customer transactions. There should be a code of conduct aimed at customer protection. Customers' information is to be kept secret, not to share with anybody else. And then best advice to the customer, understand the customer rights, and then customers' information processed according to the customer needs. And calling a customer at odd times or so-called cold calling should be prohibited. I think empirically, what is indicated is that after 6 o'clock in the morning or after 8 o'clock in the night, nobody should call a customer until next morning. The customer should be at rest at his residence with his family. So that's called cold calling. And customer may not expect a business call or anything like that. Unless the customer expects and told you to call at that time, you should not be calling. Customer visits and so on and so forth. So, and then code of conduct includes the attire of employees as well, attire, the presentable attire, presentable attire, how to dress, and then public behavior in public places and on the street, and then maybe in the public transport, how to behave, and in the society, how to behave. Because any employee found fault in not pay the taxes or not paying the due tariffs to the local authority, and if found on not paying electricity bill or telephone bill, and then water bill, it is a bad name or ill reputation for your organization. So they have to keep the public image on super condition of your organization, because once a staff member is employed by the organization, it is the face of that employee or the presence of that employee in an event or in an organization that represents your organization. So once you become an employee of our organization, your private life is half of it, half of the life, but the other half of the life is the public life or the official life. So therefore, conduct of the employee matters, impacts the organization reputation. And the code of conduct for agents aimed at customer protection. Now there are various types of agents employed by your organizations to deliver such for delivery or perform the operational functions, or at least to provide the security services in your branches and in your organizations. So such people also should be covered by a code of conduct. The attire, the behavior, the speaking, the use of language, the helping attitude, and various other things. So the code of conduct is part and parcel of the customer charter. Then we come to a very, very important point. By the employees or any other management member, or through the provision of services of your products, if any of your customers feel uneasy or victimized or harmed, there should be a process established to lodge a complaint for the customer to be able to obtain remedy or redress for the harm or loss of financing or whatever the impact that the customer had. This is again aimed at increasing the reputation of your organization and increase the reputation of the industry at large. So according to the customer service directive, customer charter directive, every organization must appoint a senior officer with adequate command as complaint resolution officer, complaints handling officer. And then there should be a methodology to accept such complaints. The good old days, there was a complaint book kept at the customer lobby for the customer to write the complaint, but now it is more active and then more facilitated through technology. There should be the complaints handling officer's name, contact number, postal address, email address, and various other facilities provided and then displayed in your website and the customer service lobby areas. So for anybody who have been feel victimized, for them to lodge a complaint. And such complaints, when lodged, should be quickly attended to, and then finally an answer provided to the complainant that the matter is receiving our attention, or matter or an explanation how it happened, and then if the customer feels loss of some funds or interest, then how the bank is, how your organization is going to compensate. And such resolution by the complaints handling officer will take a long way in maintaining the customer relationship, because unsatisfied customers can, by word of mouth, can carry to so many people about ill marketing of your organization. You can lose a lot of business. So therefore, an arrangement to resolve complaints of that nature will negate any ill marketing of your organization, and in fact increase the positive marketing when such customers speak at the public or to next door neighbor that organization resolve my issue within minutes, within hours, within a day, within a week, and so on and so forth. So the customer, not only the customer will be satisfied, but he will be an ambassador for your marketing efforts. You can turn the negative marketing into a positive marketing. So if by any chance the complaints handling officer or resolution officer resolution provided is not amenable or not accepted by the customer, then there is an organization called Financial Ombudsman. And Financial Ombudsman project is considered to be one of the satisfactory projects in the financial industry, where the Financial Ombudsman so far had been a retired judge, either appeal courts or Supreme Court judge, or only once there was a senior bank appointed to that position. And this Financial Ombudsman and his office staff is maintained by the entire banking industry. All the banks pay their salaries and the maintenance of office, and then so on and so forth. So, however, out of the complaints received by the Financial Ombudsman, majority, about 80%, have been resolved in favor of the customers. So that is the reason why it is considered a satisfactory project. So therefore, Financial Ombudsman, once the complaint is received, they will give a date for hearing of the complaint to the customer, and then summon the staff involved in the financial service organization to their office to listen to the complaint and then mediate a resolution between the customer and the organization, so that it helps the customer to resolve his animosities or loss. At the same time, help the organization to nip in the bud any complaint that had been risen against the organization, which may go into public if not resolved amicably. So that's the financial ombudsman. But then the details of financial ombudsman contact and the email addresses and the telephone numbers and the names of the people also has to be displayed in the websites or the customer service lobby areas for any victimized customer to reach out to the financial ombudsman. At the moment, the financial ombudsman office is located somewhere in Bumblepitia near the police park. So it's a mini court. So then any victimized customer who is not happy with the decision of financial ombudsman as well is free to go to the courts and through lawyers and all that. So that fact also must be indicated in the website on the complaint resolution chapter. So just imagine how comprehensive the compliance plan or compliance policy should be, incorporating all these things, KYC and customer charter, and then specifically complaint resolution. Okay. Then the customer charter also speaks of special attention and care to the customers, especially clergy, when Amduro or the priest of the Catholic or Hindu or Islam religion comes up to seeking products or services of your organization, how you should treat, how you should serve them. And then senior citizens, they expect a lot of affection. And then professionals, you need to be very professional with those guys. Those with physical disabilities, and there's a Parliament Act as well for physically disabled or people providing access to walk into your office, and especially the toilet facilities and special toilet facilities required by them. And those who cannot read and write, they are a most vulnerable category. Those who cannot read and write, there should be an arrangement in your organization if such person comes to fill up the forms and then speak to them inculcating a little bit of trust in them, because they may not understand what is written in a form, what is written in a form, on an agreement. So therefore, those who cannot read and write has to be handled with greater care, because the potential or possibility of complaints out of such people is greater. Say that they have been hoodwinked or they have been misled or something like that. So customer charter regulation require each and every organization to have an arrangement for such people as well. Then customer charter regulation speaks of the obligation of customers as one single point, just to indicate that the fees and legal fees and commissions and other levies charged by the financial intermediary should be paid by the customer. That is the only responsibility or obligation indicated in the customer charter regulation to the recipients of the services or products or the end users of the bank or the finance company. Okay. Then I thought of speaking of the code of conduct for employees at a little length. This is, as we discussed, aimed at customer protection, code of conduct, and customer convenience, customer transparency, transparency of activities, transparency of transactions, transparency on calculating interest on a loan amount or a deposit amount, increase reputation and integrity of the bank. Code of conduct is going to increase reputation and integrity of the bank or finance company. Then focus employees on areas of ethical risk. Focus employees on areas of ethical risk. Provide guidance to employees. Code of conduct naturally provides guidance to the employees how to behave in front of customers, how to interact with the customers, use of language, and how procedurally the transaction must be processed. Any comments after that? Any questions? No? Okay, let's go forward. So I have put summarily, now I explain most of the key features of the compliance plan of an organization, and which should be incorporated in the compliance policy as well. How to develop this such compliance plan? Firstly, there should be an extensive research carried out of your organization and the requirements. Not only organizations, the industry as well, how your peer organizations provide their services, how the industry expects a member of organization to behave. It's an extensive research. You must put down all the points and consider what is important. Then develop a draft of a compliance policy. Develop a draft of compliance policy. That is also very important. A draft of compliance policy to incorporate your research findings, and then communicate with stakeholders, seek their views and opinion. Specifically, each and every business head, business leader, and their job role, what is expected out of them. And then IT support, technological support, use of web services, and then specifically infrastructure provided to report suspicious activities identified by at a remote branch or a business unit located at a different geographical location. Most of the organizations have their intranet developed, facilitating both two-way communications. Especially the compliance and the head office will have to communicate the new laws and regulations and how to interpret them and how to explaining certain things. Then from bottom up, employees will have to report such activities. Some are confidential in nature, some are not so confidential, but maybe only aimed at your organization, not meant for any outside organization, confidential to your organization only. So the two different categories are that something like suspicious activity reports and confidential reports, only relevant to the compliance department and the employees who identified suspicion. And other categories that the periodical financial reports that need to be sent to the head office of finance department and so on and so forth, need to be sent up from the branch level to the head office. So the communication facilities, two-way, has to be established with a comprehensive outlook. Then develop compliance controls, specifically internal controls. Internal controls has to be developed. And then compliance must be overlooking the setting up of internal controls and then administering and then managing of internal controls on a regular basis. Then rehearsing the compliance controls and monitor for deficiencies. Rehearsing internal controls and compliance controls and monitor for deficiencies. Because this is going to be the real crux of the matter in the successful operation of your organization. If there are no robust or comprehensive controls, then it is a human nature that one employee might think differently, and then controls can be weakened. So this may lead to compromise of the achieving of your goals of your organization, financial goals, and then marketing goals and operation goals as well. Then support staff to maintain compliance. Support staff to maintain compliance. So all these steps are very important to follow. I just give them as a guidance for you. And then after a very well implemented compliance plan, you can just see that these aspects are incorporated or not, and then if not, update them. Then training. Focus on training all relevant staff on their organization. Focus on training all relevant staff on their areas of work with a view to obtain minimum output, or should be maximum output, I'm sorry about it, to obtain maximum output. Can you change that, please? Maximum, to obtain maximum output. Then maintain, what I would have meant is that minimum issues or problems, but maximum output. We were to obtain maximum output with minimum issues / problems. Please update your presentation or your paper with that wordings, please. Then maintain effective relationship with the relevant external bodies. Very important. The compliance head and then the compliance department should have the excellent PR skills when it comes to maintaining a relationship with internal departments, internal stakeholders in the first place. Secondly, they should have the excellent PR skills of maintaining effective relationship with external bodies. Who are the external bodies? The external bodies are the regulator, the auditors, the tax authorities, the law enforcement agencies. I have my personal experiences when we maintain excellent relationship with especially the law enforcement agencies. When something is investigated in your organization by the law enforcement organizations, just your word can be accepted by them if you maintain an effective relationship. Your word can go a long way in resolving such disputes, such investigative queries, if you made an excellent, effective relationship. Even with the regulator, it's the same thing, or a law enforcement agency. Even for that matter, even an external auditor or a tax authorities, also, if you have an external relationship, more than half of the problem is resolved with your effective relationship. So that PR skill must be cultivated in all compliance staff. Then respond requests from external bodies and seek consultations. Any question, please? No? No question? Okay. Then respond to requests from external bodies and seek consultations. There can be many queries from the regulator, FIU, or bank supervision, non-bank supervision, or insurance board, or SEC. Those requests must be responded to within the shortest possible time and seek consultations. Can you mute your mics if you do not have any question, please? So please unmute only when asking a question, please. Thank you, or expressing a comment. Thank you. So responding to queries by the external bodies is extremely important, so that they know that you are a agile organization. You are agile organization. So that it is very important to create that public image. Similarly, effective relationship with the external organization, and then the responding to external requests by the external organizations. Then identify non-compliant activities and remedy the situation. We must identify the non-compliant activities and remedy the situation as quickly as possible. For some non-compliant activities, you might have to seek the support of the operations or the IT departments or the technologies supports, maybe sometimes external organization who are providing the software support or IT support. Then sometimes in recruiting suitable staff, you might have to liaise with the HR and then probably external headhunters and then such organizations. And also one important point is that KYE, know your employee. Before hiring an employee, most organizations do check the background of the employee as well. Apart from the fit and proper tests that are being carried out by the central bank or the regulators, first and foremost, KYE, or know your employee methodology adopted by your organization, depending on the comprehensiveness or the capacity of your organization, it is very important. Then invite and prepare inspection visits by the regulator bodies. Once you are confident of your compliance plan or compliance policy implemented, you can invite the regulator, FIU, or the bank supervision or non-bank supervision, or auditors, or any other authorities, external bodies to friendly visit. That is going to go a long way, because they know that you are confident of your arrangements, and the side benefit is that if you have thought differently of an issue, they might come and correct you. They might come and say that this should be this way, not this way. So therefore, invite inspection visits on regulatory bodies rather than, I know most of the institutions, they do not like, they resist sometimes visits by the regulators, but they cannot do so because they are mandatorily required to do on-site examinations and correct yourselves on many occasions. So I must tell you that particularly the risk-based approach, which we discussed a couple of weeks back, is designed by the FATF and then also APG and then also the local regulators, is to rank the different organizations functioning in the economy of the risk understanding, risk measuring and risk managing capabilities. And then when you have a self ranking on your risks perceived, that helps the regulator to carry out on-site inspection on more riskier organizations more frequently and more regularly. And then less risk organization, they might program their visits on less frequency and maybe annually sometimes. But more risky organization can be visited more frequently, maybe every quarter. So that's one of the outcomes of risk-based approach. I think I did a good explanation on the risk-based approach about 2-3 weeks prior. I must tell you at this point, on a final examination, there can be a question on the risk-based approach. So please read through on the risk-based approach thoroughly, so that question for about 20 marks can be on a risk-based approach. Core knowledge required by the compliance role. Purpose and structure of the financial services industry, including the main types of institutions and the organization. I think I covered this under the research component on developing a compliance plan. Then areas of financial services are regulated. Areas of financial services are regulated. You must know what areas are regulated to be incorporated in your compliance plan. Then financial services products and financial services product types and their functions. Well, each and every product, what their functionality is. Then the financial assets and classes and their features covering past performances, risk and return. Meaning of compliance in relation to the financial industry. Meaning of compliance in relation to the financial industry. So all this is very important knowledge you should bear when designing a robust compliance plan, compliance policy. Okay, sorry about it. Compliance role is a statutory job because Section 14 of FTRA number 6 of 2006 indicates that a senior officer with adequate command in the hierarchy of organization chart of the bank or a finance company should be appointed as the compliance officer. I know one of the large institutions in Sri Lanka, when they want to appoint a senior manager as a compliance officer, the central bank, the regulator said due to the size of your organization and the complexity, there should be an AGM, assistant general manager, in the seat of the compliance, not a senior manager. But there was nothing wrong in the character or the fit and proper test of the senior manager, but they said the compliance officer should be an assistant general manager. So likewise, the central bank, the regulator, any regulator can indicate that the provisions of the section 14 of the FTRA with regard to the role and suitability of a compliance officer. The responsibilities of the compliance officer and the compliance department is indicated in the Act of Parliament. I think one full page in the section 14 describes the responsibilities of compliance in a financial services organization. So legal framework to be covered under compliance plan. Basically, Monetary Law Act number 58 of 1949 established the Bank Supervision Department and defines functions, defines the position of the Director Bank Supervision and the responsibilities. And then comes the Banking Act number 30 of 1988, and there are several amendments thereafter. And then how a procedure for licensing of persons carrying banking and financial institutions business of accepting deposits and investing such money. The importance is that the savings of a society is being accepted as deposit by these organizations. So savings of a society is very important for the development of the society. And then if the savings are wasted or savings are skewed to a certain community, certain family, or certain industry, then it's a great disharmony in the unjust behavior of the organization who manages such deposits or liabilities or collected funds. Then acting in concert, that means the various shareholding or the shareholders of an organization, when their capacity of voting power is restricted to 10% or 15%, they get together and then conduct business according to the whims and fancies of their personal agendas. So which is acting in consent. It is proven in courts of in Sri Lanka that shouldn't be done. It's a wrong thing to do. Then fit and proprietary of directors and key management. That is to say that if the if it is if you employ or if you have a director or key management person with a not so suitable character or features or past record, then there can be a lot of problems expected in conducting business activities. The time is 10:30. Can we go for a small break? Half an hour? If everybody is agreeable, we can come back and resume discussions at 11 in the morning. Is that okay? Is it?
Okay, sir.
Thank you very much. Okay. So we'll come back at 11 a.m. in 30 minutes time, right? Are you all back?
Yes, sir.
Thank you. 2 minutes more, but We shall start then. So now, developing a compliance plan, we explain part by part the key components, and then the next presentation I will, as I promised, I touch on two key areas which should be covered in depth as an example. So for other areas also, like credit administration, loan approval, then leasing, credit cards, debit cards, deposits, accepting, all those areas should be covered in depth. But because of the time constraint in this course, we cannot cover in depth every aspect of functionality of a financial institution. However, I chose to cover two areas with the time available. Excuse me, please. Hello. So the legal framework I was touching on, in the banking area, banking fraternity, Montreal Act and the Banking Act number 30 of 1988, procedure for licensing. I was fortunate enough to have a first-hand experience of procedures to obtain licensing with the incorporation of Cargill Bank. So the procedure for licensing, obtain license for the persons carrying on banking business or accepting deposit in investing such a money. I was explaining the area to regulate by the regulator is that when authorized bank accepts excess savings from the society, they should be judiciously distributed among the needy deficit units or the businesses or industries that should be developed for the country and for the society. Then acting in concert, I explain. Then witness and proprietary of directors and key management, I was explaining. Then maximum percentage of ownership of shares, especially in the banking sector, is generally restricted to 10%. On exceptional circumstances, only they allow up to about 15%, because that is again one party or one concerted group of parties driving the lending process of pooled public funds to certain categories, individuals or corporates or certain geographical areas, with detrimental to others. So expectation is to evenly allow all the industries, all the geographical areas, and all the communities to have access to the public funds collected by the deposit-taking institutions. Then the use of the name of the bank, bankers, banking, etc. is also restricted, and then closely perused by the regulator. The investment power of LCBs and LSBs again is regulated because they are the main intermediaries who collect public funds, who accrue the pool of funds, and then they are required to perform a public function or distributing the public savings collected to the needy sectors. Minimum capital requirement, as you all know, minimum capital for a bank is something like a huge amount. I think it's going to be increased to 10 billion or something in the near future. That is because they are considered systemically important banks, and then also that's a large 4 or 5 banks, and then there are other 2 banks also. They are systemically important, all right, but because of the size of the pool of funds that they manage, they need to perform.
Hello.
Yes.
Mr. Manoj here. Shall I disturb you?
Yes, please, Mano, go ahead.
Yeah. Now, with regard to minimum capital requirement, there are a regulatory standard which here the bank should maintain minimum levels. Then, if you can share with us some those limits in future, it's very grateful.
Minimum capital requirement there.
Yeah, there are certain limits. If I know, just so that systematic reports banks, there's a certain higher limits, and then other banks and the financial institution, there's some other limits, there's lower limits.
Yes,
if you have some information about that, you can share. That's great.
Will do, Mano. Thank you very much for the request, and then I will go through it and then share with you all the minimum capital requirements. But thank you very much for that comment, Mano. That is to indicate that the systemically important banks are performing greater function in maintaining the balance of the balancing act of the pool of funds, or distributing them to the needy sectors equitably, and then in such a situation they should be adequately capitalized. They should be adequately capitalized, because if when they cover a broad band of activities and a geographical coverage, they cannot be weak institutions, and they cannot fall at any cost. So that is why they are called systemically important banks. So they are expected to be adequately strong with capital base, wider capital base. That is what he meant by Mano's comment. So then, again, investment powers of licensed commercial bank and licensed specialty bank also explained there. Then minimum capital requirement we will share with you once we get the information, or once I go through them. Then liquid assets of licensed commercial bank and licensed specialty banks are also very extensively covered with Basel III requirements, liquidity cover ratio, and then net stable fund ratio calculations, and submitting of calculated reports to the regulator is a requirement. The difference between the licensed commercial bank and licensed specialty banks only a narrow path, where demand deposit accounts are the exception for licensed commercial banks, whereas licensed specialty banks do not carry demand deposit, rather current accounts, checking accounts or current accounts. So that is the legal framework for banks. Then legal framework for non-bank financial institutions. Basically, Finance Business Act number 42 of 1988 governs the legal framework for non-bank financial institutions or registered finance companies. At the moment, the number of entities under RFC is something like 39 or 40. After that, they have brought in banding for 3 categories: stronger banks, stronger RFCs, and then medium-sized ones, and then weaker ones, So therefore, and then also recently they brought in a action plan to restrict the number of registered finance companies up to about 25, encouraging them to merge among themselves or get merged with the banking if there's a bank in their group of companies, to merge with the bank. So therefore, and the banks are also encouraged to merge with any other weaker registered finance company if they feel comfortable in doing so. So again, the registered finance companies, the 39 or 40 companies, procedure for licensing and persons carrying on finance business of accepting deposits and investing such money is regulated. And then fit and propriety of directors and key management also the key feature in the legal framework. Then maximum percentage of ownership of shares. Again, I think it is a little more liberal than banks, but I think it is restricted to 15%. 15% of the total capital can be only be contributed by individual or single party. Then acting in concert again is regulated there. I think the legal framework applying to the banks again applicable here. Then use of the name finance or financing, etc., is also regulated. Then investment powers of registered finance companies are also regulated to a great extent, because again the same principle, where the equitable distribution of collection of savings from the public as advances and loans and for the needy sectors. In the case of RFCs, the minimum capital requirement is, I think, currently about 2.5 billion, and tier 1 capital requirement is about 8.5%. What is tier 1 capital? If you anyone can comment? You know what is tier 1 capital? That is the shareholders' funds, the shareholder contribution to purchase shares, and the reserves belonging to the shareholders. Shareholder funds, tier 1, should be 8.5% of the total capital. The liquid asset ratios of RFC is similar to banks. They need to maintain reserves with the bank as fixed deposits, and then investment in treasury bonds, and then also vault cash is counted as liquidity. So legal framework is quite similar, except in the case of registered finance companies, it is little liberal than in the case of banks, because banks do command a bigger slice of the savings and then pool together compared to the RFCs. Sorry. Then the legal framework attributable to the anti-money laundering and combating of financial terrorism. These 3 Parliament Acts, it's very famous, and then I think you may be well aware with it now. All 3 are based on the Financial Action Task Force recommendations as the regional body, Asia Pacific Group of Money Laundering, APG. So going by that, Convention on Suppression of Financing of Terrorism Act number 25 of 2006, number 25 of 2005, sorry. Then Prevention of Money Laundering Act number 5 of 2006, Financial Transaction Reporting Act number 6 of 2006. Yes, any question? No? Okay. So these are the three Parliament Acts that are focused on anti-money laundering and then Combating of Financial Terrorism Act. And these three are made superlative Parliament Acts because whatever the provision with regard to any issue discussed in these three Parliament Acts supersedes any other Parliament Act discussing the same issue. Same issue. So they need to be given superpowers to administer the money laundering and terrorist financing activities. One such example is that in the Banking Act, they discuss the customer secrecy law. Customers' details cannot be shown or shared or displayed to any other party by the bank, other than empowered by the customer himself or by court of law. But the FTRA requires, but the three parliament requires any suspicious activity to be discussed, to be reported, and then investigated through the regulator, FIU, and then law enforcement agencies, specifically police officer higher than the grade of ASP can ask for details of any individual that is suspected or that is being investigated. So the provisions of these three acts overpower the provisions of any other act when it comes to the same issue. So there should be a mention in this regard in the compliance plan that with regard to the legal framework. Then other directions which are important to compliance subject is direction number 2 of 2007, ownership of issued capital carrying voting rights. Then direction number 10 of 2007, maintenance of capital adequacy ratio, capital adequacy ratios, maintenance. Usually they are computed by the finance department, but the compliance should have an overall view of how the capital adequacy ratio behaves, how it is computed, what are the components in your particular organization, unique to your organization, and how can it be improved, and so on and so forth. The direction number 12 of 2007, corporate governance. Corporate governance is a different concept altogether. In your compliance plan, you should describe how the best of corporate governance is practiced, coming out of shareholders, the board of directors, and the senior management. Shareholders run this business. They are the owners of the business, and their representatives are the board of directors, appointed board of representatives. And then board of directors have immense power, and then also responsibility with regard to the minority shareholders, and then also conduct of business affairs. Then they appoint the management as their agents. It's an agency relationship, the senior management. The agents should perform their duties, the functionalities, to the best interest of the principal, who are the shareholders represented by the board of directors. And therefore, this corporate governance concept and the rules are associated with such magnitude and then such high power in a financial organizations. Next semester conducted by Mr. Vijayaratna, Public Corporate Governance, is discussed at a detailed level. So due to the constraint of timing, I'll leave it at that for the moment. So the direction number 4 of 2008, classification of loans and advances. Classification of loans and advances, especially to identify the non-performing, past due, special mention categories. Those categories are classified with a specific time-bound criteria running up to 180 days or 6 months, starting from 60th day of non-payment of the first installment, the category of special mention, and then so the compliance also should be monitoring these aspects very closely. Then number 7 of 2011, integrated risk management. Integrated risk management. Compliance is in the middle of it. Credit risk, operation risk, market risk, and liquidity risk all combined and conjoined together, and then should be managed in an integrated form. So the basic responsibility is under the risk manager or chief risk officer. However, the compliance should have an overview of risk management as well. So therefore, compliance need to really be aware of each and every risk component, identification, management, and then up to the de-risking part of it. You know what is de-risking is, we discussed some time back, where the unmanageable risk component, if the return is not adequate, most of the financial institutions shed the relationships or the products, which is called de-risking. Then direction number 8 of 2011, customer charter, we discussed a little bit detail, should be a greater part of the compliance plan. Then direction number 2 of 2012, outsourcing of business operations. Outsourcing is permitted on many functionalities except for few, including compliance subject cannot be outsourced. Key functions of the bank or financial institutions which cannot be outsourced includes compliance, but other functions can be outsourced. So outsourcing of business operations is also should be closely monitored by the compliance, including establishment of code of conduct for outsourced personnel or agents should be covered in the compliance plan, because the agents or the outsourced personnel also deliver the products or the services of the institutions or support the delivery of products or services. So therefore, they need to be closely monitored. The action should be closely monitored in the best interest of the customers and customer rights, client protection. Other important compliance requirements are single borrower limits. The single borrower limits are such that there's a percentage, something like 20-25%, and then also out of the total loan portfolio, total loans and advances should be single borrower exposure can be only about 40%. The percentages may have changed since, but there are 2-3 criteria of restrictions of single borrower going for large amount of borrowings from any institution. Then related party transactions. Who are the related parties? The board of directors and the senior management, their family members, their acquaintances, and relatives. The biggest job, because difficulty in the compliance job is to maintain such a name list of the main shareholders, directors, and the senior management, their family members' names, their close associates' names, and their exposure to the bank by way of deposits or by way of advances. So this is a gigantic task, usually performed in conjunction with the company secretary, because some of the information with regard to the directors and major shareholders are confidential. So because of the confidentiality, compliance has to liaise with the company secretary to maintain such a name list. And against each name, we must list the deposits made in the institution by those individuals or companies, and then also loans and advances taken by those individuals or associates, companies. And then there should be a restriction, and then for each related party, there cannot be any special treatment compared to the other categories of customers. Meaning, any related party depositing money in the institution cannot be paid a higher rate. It should be the same rate that offered to the other categories of customers. And on the other hand, loans and advances granted to related parties has to be charged at the same rate charged for similar loans and advances to other categories of customers. And the institution cannot give any concessional rates of lower rates to such loans and advances. And then over and above a certain specific threshold, a related party transaction has to be approved by a board, subcommittee or main board before execution of such transaction. So these are the main components of compliance plan, ultimately arriving at the control compliance culture, compliance regime of the organization. So they must be documented, the points must be documented in the compliance policy, and this plan must be also drawn up and then approved by the IRMC, Integrated Risk Management Committee, as well as the main board when required, and then should be disseminated to each and every head of business unit so that they are aware how to transact, how to deal, how to hold hands with the compliance with each and every move when it comes to the execution of business activities and then compliance role. One other area that I had forgotten to incorporate here is that introducing new products and services. New products and services introduction also the process need to be documented in the compliance policy and the compliance plan. And then these new products and services whenever they are to be introduced or implemented, each and every stakeholder, or the function holder in the organization, including finance, HR, operations, IT, audit, and compliance, and any other related party, an involved party, should draw up a new product document with the name and then functionality and the features, and each and every authority that we just mentioned must indicate their comment after having gone through the entire document. And then those concerns must be addressed by the promoter of the product or service. And then only after that, with the feasibility study and with the approval of the strategic planning committee of the bank, and then the business development committee of the subcommittee of the board, the new product or service can take off the ground. So such developing compliance plan should be taking place in an organization. So it demonstrates how the compliance should have the overall umbrella view of control of the affairs of any organization, bank or finance company. So any question before we go into the other specific areas? No questions, no comments? So I told you that I will cover the treasury aspects as well. And if the time permits, we'll cover the trade finance unit action as well. The compliance plan and compliance policy, there should be specific detailed approach for treasury functions. The treasury is considered the wholesale banking unit of the bank or the finance company, wholesale bank. You usually collect deposits from various corners on geographically wherever your branch network is located, or now in the modern day through websites, deposits can be accessed even if there is no branch present in that locality. So therefore, it is a virtual, it can be virtual bank, virtual finance company. So therefore, those deposits collected as a total liability base, then they are allocated with the business guidelines, business criteria decided by the board subcommittees and the ALCO to the various investment and the loans and advances of the organization to various industries. So that is called investment policy. There should be a separate investment policy. So say it's 100 billion deposit base, you allocate loans and advances 60 billion, investments another 15 billion, 75 billion, total, then other infrastructure and other cost of any other fixed assets and sort of things, 5 billion. So 80 billion or 80% of the total deposit base. Balance money usually is handled by the treasury in the wholesale form. Large transactions and quick decisions and committing the bank or the finance company to huge sums of money to be acquired or to be paid out, depending on the scope of the treasury function. So therefore, in some cases, the specialized treasury officers or senior dealers or treasurers may have the powers equal to or exceeding the board of directors, although they have been empowered by the board of directors to do such transactions. For a single transaction, sometimes they may have huge power in committing the bank or finance company to such transactions, and therefore they need to be controlled. Their actions should be monitored because their single action can make or break the entire institution in no time. There have been examples in the world. Good example is that Barings Brothers Bank, a large merchant bank with centuries old in UK, which was the banker to the royal family as well. One of the traders, one Mr. Nick Gleason, he single-handedly destroyed the bank after committing for some treasury transactions in derivatives or call options at their branch in Singapore. Whilst he was appointed the general manager of Singapore operation, his background was treasury when he was back in London at a junior position. So then with the knack for trading, when he was appointed as the general manager of Singapore branch, he resorted to, being the general manager, he resorted to do the trading himself. And that is a violation of corporate governance again. When you are the overall chief executive officer, you cannot sit on a trading desk and then deal, because the trading desk must be reporting what are the functions, must be supervised and then controlled by the CEO or the general manager. But he himself took the helm, took the reins to his hands, and he was dealing. Unfortunately, after the earthquake in Kobe, Japan, Japanese yen call option contracts, after having dipped in prices, took a severe beating. But this guy in Barings Brothers Singapore branch had held on to some call options, which lost a huge amount of money, and finally amount of money more than the capital of the bank was lost. So finally, Bank of England tried to resurrect the institution. They did not able, and they, on principle, they took a decision not to salvage the bank because it had violated a lot of fundamental corporate governance rules, and therefore they allowed a Dutch bank, ING Bank, to take over the entire Barings Brothers Merchant Bank, centuries old, banker to the Queen and the royal family, to be bought just for £1, £1 because the liabilities stood so high that the selling price of the bank to ING Group was £1. That's a nominal consideration of £1. So So treasury operations has to be monitored and then controlled via the middle office or the risk management unit of the bank, and the back office or the finance department of the bank or the finance company. So therefore, in summary, segregated reporting lines and monitoring by the compliance. The treasury is normally divided into three parts. Treasury front office is the unit which carries on transactions to invest or to borrow or to buy or to sell foreign exchange and various other treasury activities permitted by the board of directors. And they do the transactions, they perform the transactions to pursue the business activities of the bank, including maintaining the reserves and the liquidity for the bank or the finance company. And this function must be reported to the CEO, Chief Executive Officer, because he is the guy who is responsible for the business targets of the bank or the finance company. So therefore, like in the case of Baring Brothers, CEO can't go and sit in the front desk and then treasury and then do transactions. He must be overlooking what is happening and giving guidance to the treasury front office to achieve the desired results, targeted performances, profits, market share, and so on, so many other business measurements. So then this entire process must be monitored by the compliance and reviewed by compliance, whether this happens as expected. So therefore, compliance unit must have the know-how to oversee the function of the treasury front office and as supervised by the CEO of the company. So compliance unit therefore has overall power in monitoring and reviewing these activities of the front office. Then the second section, treasury middle office, is a newer concept and should be reporting to the chief risk officer of the bank or the finance company. And then their function is to align the risk versus return arising out of these transactions executed by the treasury front office. If there's any anomaly with regard to the return out of the risks that they undertaken, or whether the risk appetite decided by the board of directors is exceeded by this treasury front office activities, has to be supervised by the CRO, Chief Risk Officer. It is basically to minimize losses and maximize returns, maximize profits. So therefore, the function of the treasury middle office is extremely important. There again, compliance coming to the scene to monitor and review whether treasury middle office, whether they have the capability, they have the understanding, they have the knowledge, and whether they do practice the risk return alignment, and then whether they are really capable of monitoring the front office transactions as and when they happen. So much so that when the transactions are executed by the front office, they don't go into the books of the bank straight away. They have to be perused by the middle office and authenticated by the Treasury middle office before the Treasury back office books them into the books of the bank. Then the third unit is Treasury back office. Treasury back office reporting to the Chief Financial Officer. These guys are the custodians of the pool of funds of the company. So the custodians has to see whether the performance of the Treasury front office in executing the large value transactions are in accordance with the economic goals set by the board of directors and the ALCO, and then thereafter they must approve the transactions to be recorded in the books of the company, and then they have the onus or responsibility of analyzing and comparing the performance of the Treasury front office transactions and reporting to the ALCO, IRMC, and the other board subcommittees with a flair of comparison with the peer banks, peer companies of similar size, whether they are bringing in adequate revenue, adequate income to the company as demonstrated by the peer similar size companies and banks. So this function is also there again monitored and reviewed by compliance. So mind you, Treasury front office, Treasury middle office, and Treasury back office functions and the responsibilities and the actual handling should be monitored and reviewed by the compliance. So imagine the compliance, the knowledge base of the compliance that should be with them, large transactions, financial products, financial instruments, treasury bills, treasury bonds, foreign exchange, outright transactions, forward transactions, swaps, then derivatives transactions, when whatever they do transact, or they are permitted to transact, and whether they are doing it with authority or to the limits that have been established. All that should be monitored by the Treasury middle office. Then once they approve, they must go into the Treasury back office. And when they book into the books of the bank, and then all sales and deliveries has to be made payment by the back office. All the money is received to the nostro accounts must be received and reconciled amount of money without a reduction of and paid on time on the value dates by the Treasury back office. And all these are monitored and reviewed by the compliance. Any question, any comment? You understand? Yes, no? Yes? Do you see the screen? You can see the screen,
Yes.
right?
Yes.
So are there any questions? Did you understand the concept that I read out?
Yes, sir. Understood.
Thank you. Thank you. Because most of the institutions, even the large banks, I'm sure is not practicing what is written in black here, monitoring and reviewing for the compliance. They may be having the treasury middle office and they may be doing their job. They may be having a separate treasury back office and they may be doing their job. But the role of compliance, I doubt very much whether many institutions practice this. It's a monitoring and reviewing or surveillance role. Because compliance has the overall responsibility of the performance levels of the company or the bank. Compliance need to stand tall and then be able to correct any anomaly to achieve the desired results or targeted profits. Especially in the case of treasury, as you all may be knowing, the net interest income or the difference between the interest charged on loans and then interest paid to depositors, net interest income, if you compute in a balance sheet of a bank or a finance company, it is a fraction of the total profit that is reported by this bank or a finance company. Majority of profits are earned or channeled or organized by the treasury function, the wholesale banking unit of bank or the finance company. You may, at your leisure time, take a balance sheet of a finance company or a bank and then compute the net interest income, which is supposed to be the core income of the financial organization, is a fraction of the total profits received. Finally, the total profits, whether it's before tax or after tax, reported, major share or lion's share is generated by the treasury or the wholesale banking units of the bank or the finance company. So that is why it's really important for the compliance to understand the functionality of the three units of treasury: front office, middle office, and back office. And then understand the practical aspects, whether they are following, whether they are on course to achieve the target profits or market share. If not, what are the obstacles in between, correct them, and pave the way to achieve the results, required results. So the compliance role is very much more advisory and then corrective, sensitive, with sensitized or forward-looking or futuristic manner. Auditing, internal audit or external audit is all historical, but compliance role is all three: past, present, and futuristic as well. just an example, in this process, if the front office treasury dealers say, for example, the trader of government securities, treasury bills and treasury bonds, he or she does not apply themselves and then go for the profits that actually are there, because that was demonstrated very much during the last 2 to 3 years, where the interest rate curve of this country, interest rate curve, was steadily coming down, reduced. You remember? Those days, the interest rates were around 10%, 11%, 12%. Now it is 4, 5, 6%. So about half, about 50% now, total interest in absolute terms. Interest rate curve was reduced in several locations to be brought down to these levels. Now, as you all know, the price of a treasury bill or treasury bond goes up when the interest rate is reduced. There's an inverse relationship. The face value of treasury bill or treasury bond is usually 100 rupee. And the price is indicated whether it is 100, then it's called par value. If it is 101 price for every 100, then it's at a premium. If the price indicated at 99 or 98 per 100, then it's at a discount. Because on maturity of treasury bill or treasury bond, you always receive 100. That's face value. So the price, market price, might be lower than the face value. In the case of it is a discount, or higher than the face value, it is at a premium. So one of the major dependent factor for the treasury bill or treasury bond to be a premium or discount is the interest rate of the country. But the interest rates were reduced steadily for the last 2 to 3 years, from about 12% to about 4 or 5%. The price of the treasury bill or treasury bond goes up. That's the inverse relationship for the price. So during the last 2 to 3 years, if any bank or a finance company who has invested treasury bills, treasury bonds, they are government securities, zero sovereign risk, and they are taken their liquidity provision criteria as well to meet the liquidity ratios. Whatever the treasury bill, treasury bond bought at that time when the interest rates were 10 or 11 or 12%, now with the reduction of interest rates, would definitely will trade at a premium, can sell at a higher price and make a capital gain. So during the last 2 to 3 years, if any treasury front office of a bank or a finance company could not make that adequate capital gains, means they are not capable of carrying out successful treasury functions. So that is the reason why treasury back office or the finance department should provide reports containing the actual performance of the treasury front office transactions, supported by or compared with the peer bank institutions, peer finance company institutions, how they are performed at least on single size. So in such a case, if the treasury front office traders of treasury are unable to deliver adequate results or capital gains in such a friendly environment for the trade, meaning they should be, the compliance should go forward and then suggest to HR or the CEO to engage the traders or dealers with more training, skill development, and then getting the best use of them. If by any chance, if any one of these guys, traders or dealers, do not want to take that risk and then do the trading and then accrue the profits to the institution, if they are averse, risk averse, then they must be changed. New persons must be appointed to carry out such transactions. So all these initiations can come from compliance. This compliance can take the initiative and then suggest to the HR or to the CEO, the whose purview the treasury front office is functioning, that so and so should be replaced by another person who could deliver results. Compliance can take that initiative. I myself have done it when I was handling compliance of a bank. I initiated and had a very friendly chat with these treasury guys who would listen to you, and then finally when the results achieved were not so admirable, then we were able to change the guys, set of people, appoint people to function that particular desk and achieve fairly satisfactory results. So that is how the thinking and then powers of the compliance department should be. So I thought of just running through whatever, just 1 hour more. We'll try to run quickly. The new, you understand what is the treasury front office and treasury back office equally. The new concept of treasury middle office, I will explain a little bit more. Why do you need a treasury middle office? Recent events have shown that fundamental failings in internal controls can result in severe financial losses or even insolvency in financial institutions. Robust controls need to be in place to ensure transactions are undertaken in accordance with appropriate strategies, policies, and procedures of the bank or financial institution. So therefore, usual function of the treasury middle office is that they do check the limits imposed by the board or the ALCO to be followed by the treasury front office guys. The middle office typically gets involved in the risk management and control aspects of trading and is staffed with people who are capable of independently valuing portfolios and analyzing risk positions. Remember, the treasury middle office is part of risk and reporting to the chief risk officer. So with the responsibility to minimize losses and then middle office functions are closely connected and located very close to the front office. They have to intervene or review or analyze the transactions concluded by the treasury front office before they get into the books of the bank. Entrusted with monitoring, controlling, and providing information on the front office functions and with the actual origination of the transactions. Middle office functions include risk monitoring, measurement, management, and control and reporting. So this risks identified and the revenue generated put on a two sides of the scale. Middle office or risk unit must be reporting to the ALCO role of middle office and responsibility is discussed at length. Role of the middle office, analyzing the inherent risk in each business activity, keeping track of performance, evaluating the effectiveness of control systems, forecast, simulations, sensitivity analysis, and stress testing, performance measurement, performance arbitration, performance attribution, meaning whatever the transactions that they do has to be accepted by the back office and then settled. So during that process, there is overhead costs. Now, most of the transactions are reported to the central bank for settlement, and often they use real-time gross settlements or RTGS system, which is based on SWIFT. And also in the case of government securities, treasury bill, treasury bonds, they use scriptless securities settlement system, or the CDS for the government securities, for which two SWIFT messages between the organization and then the central bank is exchanged, for which central bank charges 200 rupees per message, 200 rupees per message. So total about 400 rupees. And then when you are a member of SWIFT and then your SWIFT connection, the SWIFT head office in Belgium also sends you a bill at the end of the month for each transaction, average about 75 cents of a euro. 75 cents of a euro is something close to about 200 rupees in rupee terms. So in total about 600 rupees, there is a cost for each transaction, overhead cost. Apart from the processing by the Treasury back office, use of computer space in the core system, and other reconciliation, and then involvement of other staff. Their time is consumed for this processing of transactions. And then finally to see whether the correct amount of funds are delivered, or correct amount of funds are received, correct amount of securities were delivered, or correct amount of securities were received. Reconciliations has to happen. So many staff involvement happens. So apart from the direct financial overhead cost of 600 rupees, involvement of staff of other units, especially back office and then payment and settlement units and the reconciliation department, and also the computer saving, data saving volumes increase. So therefore, Treasury middle office should be in their performance measurement and performance attribution, analyzing the costs of transactions, whether they are actually needed or not, the transaction, whether they are actually needed or not, to pursue the profit targets given by the board of directors or the ALCO. And finally, whether they are transacting at the actual market price or whether they are transacting at the off-market rates. And also whether they are transacting within the limits provided to them Likewise, like the counterparty risk, product wise limits, and then loss limits per transaction and per portfolio. So therefore, this performance attribution is a detailed job where middle office or treasury middle office should be analyzing and if unwanted, unnecessary transactions are being carried out by the treasury front office, means they should be able to discuss with them and either abort the transactions by asking the trader to agree with the counterparty who did the transaction to abort the transaction if it is not required, or at least to prevent any future such transactions to be carried out by the front office guys. So middle office function is so much important in securing the alignment to the profit targets and other goals decided by the board or the ALCO. Responsibilities of middle office: risk monitoring, risk measurement, risk management, risk control, and reporting. So these are the responsibilities of the middle office. I know for sure many middle officers in banks particularly, they do just compare and see whether the list of counterparty limits, list of product limits, list of dealer limits, whether they have been maintaining or not. Is it? But see the length and breadth of the responsibility. Limits and ratios. Create reasonability test. That means whether the transactions conducted are as per the market, whether they are off market rates. Trading investment positions, trading. Now according to the Sri Lanka financial reporting standards and then LKS 39, SLFRS, IFRS 9 or LKS 39, there can be 3 business models or 3 portfolios maintained by a bank or a finance company. One is held to maturity, meaning you buy the government security, treasury bill, treasury bond, or any other debt instrument, and then hold it until maturity, expecting the coupon interest and the maturity cash flows to come, and the return expected is only the coupon interest that is attached to the treasury bond or the yield of the treasury bill. And they are called held to maturity. And they usually go to the balance sheet. If they at a premium, the premium amount over and above the face value is amortized over a period of time, life of the treasury bond, to the balance sheet. Or if it is a discount, then again the discount is amortized. Then the next portfolio, the business model is available for sale. That is a combination of expectation for the cash flows or maturity proceeds and then coupon interest, plus being available for sale when it is needed to for liquidity purposes or any transaction that requires to be carried out. And the mark-to-market gain or loss available for sale is SLFRS 9 is taken into the balance sheet or the reserves through the other comprehensive income, OCI, other comprehensive income. That also do not go through the P&L. Then the next business model of the portfolio is held for trading portfolio. Essentially, using the skills of the traders or dealers, they are required to be within limit. And then for short-term gains, for short-term trading purposes, they can buy and sell treasury bill, treasury bonds, or any other debt instrument for the held for trading portfolio. So the middle office also must be monitoring and then supervising whether the front office traders are buying such debt instruments to the correct portfolio. I have seen the recent past, some of the organization held to maturity purchases of the treasury bill, treasury bonds, or the debt instruments. Usually they are bought and they are kept for liquidity management reasons, and also to be used when transacting with the central bank for intraday liquidity facility transactions, and then also the standard funding purposes, standing lending facility rate, SLFR. When the company or the bank needs money from central bank, they can go to the central bank and then obtain funds under standing lending facility rate. This there is 6.5%. And for that, you must give treasury bills or treasury bonds for the period that you borrow money. So any government security in the held to maturity portfolio can be utilized for that. Then available for sale category is a different business model, expecting the cash flows plus being available for sale for liquidity purposes. Then held to maturity portfolio or trading portfolio is basically for short-term trading, and any profit or gain or loss has to be channeled through the P&L. So out of the three portfolios, held to maturity gains or losses are only channeled through the P&L, and then essentially that is used to measure the performance of the treasury front office traders. Using their skills, they need to trade such. They need to trade such instruments, treasury bill, treasury bonds, or any debt instruments recorded in the held for trading business model. Then treasury front office and treasury back office operations also has to be closely monitored. They should not intermingle. Middle office should be monitoring the segregation and reporting any violation of adherence to the stipulated criteria.
Excuse me, sir.
Yes.
On the previous slide, the trading investment position,
Yes.
it says held to maturity, available for sale, and held for trading.
Yes.
Is it possible you to give us example for each place?
Example for each trade. Okay. Okay. Now, a treasury bond bought with the approval of the ALCO and to be, say, a 5-year treasury bond with a coupon of, say, 8% coupon interest. And then that is recorded as held to maturity because for the period of 5 years, you are going to receive 8% coupon interest. Every half year, you are going to receive coupon interest of 8% for that particular 6 months. And then if it has been bought at a discount, for every 198 rupees you are paid, the 2 rupee discount, difference between 100 rupees and 98 cents, has to be amortized over the 5 years. And that is going straight to the balance sheet, or amortizing cost. So only expectation here is the cash flows. Coupon interest every 6 months and maturity proceeds of face value at the end of the 5th year. Understood? That's the held to maturity portfolio. And then the front office trader is not permitted to touch that 5-year treasury bond in the held to maturity period, held to maturity business model, because that is expected to generate interest income at 8%. That is it. And then if by any chance the company or the bank needs the money invested in that 5-year bond before maturity, before the end of 5 years, then the ALCO, the board of directors of the ALCO must decide and permit the front office to liquidate or sell that. Otherwise, the front office traders cannot sell that. Those are the criteria for held to maturity, investment purposes. Then available for sale, you buy another 2-year treasury bond, shall we say, with a coupon interest of 6%, available for sale, and there again the expectation is cash flows to receive the coupon interest at 6% every 6 months, and maturity proceeds at the end of the 2 years, the total face value. But here, if the liquidity situation is such that you need to sell this treasury bond, 2-year treasury bond, to maintain the liquidity by the company or the bank, then the front office trader can sell it with the approval of the ALCO for the liquidity purposes. And again, if that 6% coupon 2-year bond for AFSO available for sale was bought at a, say, discount of 99 rupees for every 100, that 1 rupee difference between the 100 rupees and 99 rupees has to be amortized or has to be marked to, actually it is market price, and between the market price and the face value of the bond, which is to be received at the maturity, that amount marked to market loss or gain, if the market price is at 100 rupees itself, in par with the face value, then there is no impact to the P&L or balance sheet. But if the market price is 101, and the face value is 100, then you have 1 rupee gain, 101 minus 100. So that mark to market gain has to be booked through other comprehensive income, and then added to the reserves of the balance sheet, not to the P&L. Then business model, third category, held for trading. For example, the traders buy and sell treasury bills very often in the secondary market, or the buy through the primary market, primary auctions, and they sell it to the secondary market. That profit or gain, difference between the buying price and the selling price, profit or gain, essentially they are short term, very, very short term. You buy with the intention of trading, selling. Such profits or capital gains must go through the P&L. They should go through the P&L. So that is essentially used to measure the performance or the skill of the front office traders to make money, to make capital gains. So those three are the examples for the three business models. Any other question? I hope you understood the purpose of the three business models under SLFRS 9. Both these SLFRS 9 and LKS 39 are introduced by the Institute of Chartered Accountants. And they must be followed, and there are regulations issued by the Bank Supervision and Non-Bank Supervision Department of Central Bank of Sri Lanka to adopt the SLFRS 9 and LKS 39. Okay. Risk monitoring. There can be single transaction limit. Each trader, each product can be attributed to a single transaction limit. Not more than 1 million rupees, more than 1 billion rupees. Then overall currency position, overbought or sold, overnight, daylight. Any foreign exchange, dollars or euros or Singapore dollars or Hong Kong dollars. Any buying or selling, overall currency position, whether overbought or sold, there can be a limit. Individual currency positions, overbought or sold, daylight, there can be a limit. Forward foreign exchange mismatch gap, there can be a limit. What do you mean by forward foreign exchange mismatch gap? Say 6 months forward, you buy dollars, US dollars, $10 million, maybe from customers or any counterpart in the market. And then also you have selling of $5 million 3 months forward. So there's a gap of 3 months and 6 months. 6 months you have sold, you have bought $10 million, and 3 months you have sold $5 million. There's a gap of 3 months as well as $5 million, 10 million minus 5 million. So for these, to control these gaps, there are going to be limits. Difference between the buying and selling amount, there can be a limit. maximum limit of something like 2 million, say. So in that case, the dealer either have to increase the sales by another 3 million to meet the 2 million gap limit, and then because he's not authorized to keep more than 2 million gap between the bought and sold. And then also time limit between 3 months and 6 months gap. If you are not allowed to keep more than $1 million gap limit, then he has to meet the 10 million bought, he has to increase his sales by another 4 million. So that can only keep $1 million gap. Then overall loss limit per day, when you bought or sold, either foreign exchange or government securities or whatever the instrument that you are trading, you are permitted to incur a loss of only 1 million rupees. So then whatever the position that you have taken or bought or sold in that particular instrument, you must calculate the profit or loss. And if it is in loss, and if the loss is 200,000, 300,000, 500,000, and if the loss is going to increase to 600,000, 700,000, and if it is going to meet the $1 million rupee loss limit, you must immediately unwind the position or sell the instrument, and then restrict your loss to 1 million, not more than that. Then cumulative loss limit for a month, dealer limits, all these are control risk monitoring approved by the board of directors and the ALCO, and monitored by the Treasury Middle Office. The limits and ratios, maximum tenor, there can be limit of tenor not more than 10-year Treasury bonds. Maximum of 10-year Treasury bonds only can be bought and sold. Then value at risk limit, value at risk. What is value at risk? Whatever your position, Treasury bonds or foreign exchange or whatever the position, the value of that purchase or a sale, value at risk. There are methods to estimate the value at risk, and that risk value should not exceed the limit prescribed. Then counterparty exposure, foreign exchange and money market. Counterparty settlement, foreign exchange and money market. Country limit, foreign borrowing maximum 15% of the capital funds. There again a limit imposed to restrict the vulnerability or the risk. Foreign borrowing can only be maximum 15%. Borrowing, yes, is adding to the fund base, all right, but when it is foreign borrowing, there can be big expectations by the foreign lenders, and then there can be increased risk on the company when you increase the borrowing amount. Foreign exchange exposure as percentage of total capital funds, not to exceed 30%. Foreign exchange exposure in terms of total capital funds, if it go to exceed to 30%, then the exposure should be reduced to 30%. Swap fund ratio. Do you understand what is swap here is? Swap is either treasury bill or treasury bond or foreign exchange. You sell the foreign exchange for rupees today and buy it back 3 months forward. So what do you do in effect? You have handed over your sold your foreign exchange, say $1 million in your Nostro account and generated 200 million rupees today. And then you agree to buy back that $1 million in 3 months' time and pay out 201 rupees with the premium. So for the 3 months period, you have generated 200 million rupees by swapping the $1 million, selling today and then buying it back in 3 months' time. So in your balance sheet, you have additional 200 million rupees for these 3 months. So this swap fund ratio, the 200 million, there can be a ratio limit with the capital funds or total deposit liabilities. That is called swap fund ratio. Liquid assets ratio, 30%, all eligible liquid assets as a ratio of total asset base. Loans deposit ratio, loans to deposit ratio. You have 100 million deposit base, loans can be only 60 million or 60% of the total deposit base. You cannot exceed, if there's a limit of 60%, you cannot exceed that 60%. So you can grant only grant loans only up to 60 million or 60% of the deposit base. Processing time. Once the Treasury Front Office executes a deal, there is a time limit of something like 15 minutes. We have to process the transaction before that 15th minute. Deal processing time is monitored to avoid undue delay in capturing authorizing deals to the system. Because further the delay, the market rate might change and the system might not accept the rate if it is big variant with the market rate, one thing. Second thing is that the system should notify, especially systems like Bloomberg or Reuters, which captures the market rates, should be notified of such transaction being done and the market rate, so that your transaction also is part and parcel of the market, contributing to the market rate or yield curve. Trade reasonability check through the system parameter setting, broker data or Reuters or Bloomberg, whether the rate is reasonable or not, or whether the rate is the market rate or whether it's the off-market rate. Because the off-market rate can be manipulated by the traders to hide a loss or to show an enhanced profit or to a malpractice where to share the profit through unauthorized accounts. In such an event, risk monitoring by the middle office comes as a checker whether the rate reasonability is effective or not. Front office operations, front office and back office must be independent. Customer dealing is one of the functionalities of the front office. Proprietary dealing based on bank's risk capital and risk appetite. Managing bank's liquidity. They are the functions or operations of the front office. Back office operations, deal input and verification, deal verification by confirmation, counterparty confirmation or the broker confirmation or the Bloomberg confirmation. Then the settlement, payment effected on value dates and payment received on value dates, and also Nostro account reconciliation, either the rupee account with the central bank or dollar account with the New York bank, euro account with the Frankfurt or Paris bank, Singapore dollar account in Singapore bank must be reconciled, and to make sure that the funds have been received in the entirety on the correct value date, and also on the other side, funds have been paid in entirety on the correct value date. Position valuations, mark to market, mark to market of trading positions, market volatility and frequency of position valuations, methodology, pre-pricing funding gap model, maturity model, duration model, value at risk model. These models are a little complicated, but for your knowledge, if you know that there are such models used in the position evaluation, if you know that, that's adequate for the moment, but the models per se are complicated. Then the risk management, liquidity risk, market risk, interest rate risk, foreign exchange risk, and credit risk or counterparty risk is the risk management of the Treasury Middle Office. In particular, liquidity risk management refers to the timely availability of funds to the bank or financial institution when needed without incurring any penalty or costs. There are about 8 slides more, and we have only about 20 minutes more today. Basically, they are individual market risk and then market risk management techniques, gap reporting. You can just read through and then understand. Finally, this is the copy of the first slide to show that the importance of Treasury front office and middle office and the back office. Reporting separately to front office to the CEO, middle office to the CRO, and back office to the CFO. And then overall be monitored by the compliance. The functionality is monitored by the compliance and then reviewed. So let us jump on to the trade finance part of it so that I can finish the second semester today. This is basically part of this unlawful activities. I discuss trade finance unlawful activities only. Manufacturing, trafficking, import and export, possession of dangerous drugs under the Dangerous Drug Ordinance, solicitation and no acceptance and no giving bribes, inducing and no involvement in acts of corruption, activities relating to unauthorized possession or use of guns, firearms, offensive weapons and explosives, including bombs, exchange control violation as indicated in the Foreign Exchange Act number 12 of 2017, conduct of prohibited schemes such as pyramid schemes, transnational organized crimes such as credit card frauds, trafficking of arms, computer and internet related crimes. Then offenses committed against children, offenses connected trafficking and smuggling of persons, violation of customs ordinance, any regulation, rule and order made, violation of excess ordinance, any regulation, rule or order made, violation under the Payment Devices Fraud Act, regulation or rule of order made, violation under the National Environment Act number 47, the recent ship fire disaster is under this ordinance, environment. Violation under Companies Act number 7 of 2007, violation under registered stock and ordinance, that's the treasury bonds, violations under SEC ordinance, violations under Payment and Settlement Act, offences under any other law punishable by death or imprisonment. Under consideration tax evasion in Sri Lanka, but any other countries, tax evasion is a unlawful activity under or predicate offence under the anti-money laundering laws. So if Financial Transaction Reporting Act Section 2 comes up again, where the KYC requirements and then the deposit-taking institutions are unable to maintain any account relationship without any KYC data. Then further development, CDD rules 27 January 2016, risk-based approach is very important. I said there can be a question in the exam. So guidelines issued in 11th of January 2018. The risk in relation to the customer and the risk in relation to the country, product, service, transactions, and delivery channels. These are the main features under the risk-based approach. So please read through more on the RBA before the exam. And the three main methods used by the criminals to move funds: financial systems such as checks and wire transfers is being used by the fraudsters or criminals. Then banknotes using methods such as cash couriers and bulk cash smuggling. Then the moving value using methods such as the false documentation and declaration of traded goods and services, under which the trade finance comes up. Moving value using methods such as false documentation and declaration traded under goods and services. So these are the three main methods used by the criminals to move funds. Move funds of what? For money laundering and terrorist financing issues. So trade finance related. Basic trade-based money laundering techniques. Over-invoicing or under-invoicing of goods and services. One can resort to import some goods with the overpriced, over-invoiced document. The pro forma invoice and the commercial invoice can be some percentage or big margin higher than the actual value of the goods. Why do they do that? They want to transfer the money, illegally earned money, or the money for terrorist financing to the exporter's bank or exporter's country. So therefore, they overprice the imports or under invoicing goods or services means under invoice. They show a low value of goods and services in the pro forma invoice on commercial invoice, so that the money can be kept, extra money can be kept in that country to finance the terrorism or the money laundering acts. Multiple invoicing of goods and services. Multiple invoicing for the same goods and services. There can be invoices produced several times. There was a practical issue about 5 years ago. 5 years ago, I think in the year 2016 or 17, one party was carrying some invoices with the same HS codes and then same numbers to import yarn from Pakistan and then few other countries. And then they wanted to make an advance payment. You knew that the advance payments can be made for $50,000 maximum per shipment. So then the bank that I was working, this guy came and sat down on the trade finance desk and then wanted to remit money, 49,900. So the first time it was sent, and the next week also he came again with another invoice, this time 49,500. So that was also processed, but then curiosity emerged, investigations were done, and few friendly banks was inquired. This guy has appeared in those banks as well to remit advance funds. So finally, when the guy came for third time, the guy was caught and handed over to the police. And with the invoice numbers and the necessary data was reported to the FIU, to STR, and the investigations was carried out and the guy was brought to justice. So multiple invoicing of goods and services. Invoices are just a matter of documents, producing documents. So these documents were really not so genuine, but however, they look genuine. So when the guy tried 3 times, the third time he was caught. And then the purpose was that he wanted to siphon funds to some terrorist organization somewhere in the Afghanistan. And then he was making advance payments. Over and under shipments of goods and services. Again, similar effect of over and under invoicing. Over and under shipments of goods and services to retain value or to make overpayment for the purpose of money laundering or terrorist financing. Then false described goods and services. False described goods and services to collect the money. Now, there was a decided upon case. One of the banks, I think since it is decided upon, and then I can indicate that, I think it was Standard Chartered back in Colombo, who was presented with a invoice to import certain bags or some commodity by a trader in the fort area. And then finally, when the value of shipment, the value of ship arrived at the Colombo port and the documents are presented, below lading and the documents are presented. When the value was paid, finally, when the container was removed from the port and then opened in the presence of the customs officers. It was just some waste items packed in it and not the intended commodity. So whatever the few thousands of dollars value paid had gone to the country, I think it was Singapore, and then the importer has to suffer the heavy loss. And finally, he was able to claim from, I think, the insurance. But however, the false described goods and services is another way of trade-based money laundering. Then complex trade-based money laundering techniques. There are complex black market peso exchange arrangement, for example. There was a famous, there are a lot of reading on this issue, Colombian drug traffickers to North America. The peso of, I think, Argentina. There have been some drug traffickers smuggling drugs from Argentina and Mexico to the US. And they sell the drugs in the US and collect US dollars. And there are peso brokers in the USA, peso like money brokers. They exchange the dollars for peso, and the exchange money then is siphoned back to Argentina and Mexico. So this was after pretty long time. The entire racket was busted, identified with the help of intelligence officers, and finally they put an end to that practice through the USA judicial system. So this is what I want to discuss with you today. So overall compliance plan and constituting compliance regime, and then the compliance policy, and understanding the responsibility of compliance role in a financial services organization. So I was able to describe to you in a little bit depth the treasury functions, how the compliance role should facilitate. And then in the trade finance section as well, there should be a great understanding of trade finance technology, methodology, and the language, and the process. And the compliance also should acquaint themselves with the trade finance desk guys, and then hold their hands in support whenever they locate suspicious activity to prevent any damage done to the reputation of the institution. So therefore now overall there are some of the areas also to be covered. I urge you to go through the reading material that we have provided to you, as well as read through other material through the internet, and then acquaint yourself, equip yourself with big knowledge, so that it will facilitate you with your current employment scope, as well as enable you to get through the exam. So I have given you hints right throughout of the exam question that they may come. So today I gave you one hint where the risk-based approach area, there can be a question. And also there can be another question on the compliance role on the treasury activities. Compliance role on the treasury activities. So please study that, understand the conceptual arrangement, and see that you answer successfully. Now that you all have done a successful assignment on KYC, CDD and EDD, I want you to be going through the exam with flying colors. I think it's not a difficult task. So if you only read the material well, understand, and also I can tell you that I'll be available on the telephone and on the email to support you for any queries that you may come across during the period of your study as well as your official capacity. In your work area, if you come across any issue in compliance, please don't hesitate to call me or send me an email. I will be ready to support you. So thank you very much. It's already 1 o'clock. Today I was able to cover 3 presentations. And then I think from next week, Sunday itself, Mr. Vijayaratna will be taking you through the 3rd semester, or 3rd module rather. So once again, please get in touch with me for any clarifications on queries. So thank you very much for listening all this while. Thank you.